Magali Eban, Or Brook, Giorgio Monti. Very warm welcome to the Digital Markets Research Hub. I'm very grateful for your availability to discuss one of very problematic issues in the current discussions on the implementation of the Digital Markets Act, namely the issue related to coexistence of different legal orders. And we have juristic dimension, we have political dimension, economic dimension, or geo-economic dimension here. And we also have a conflict of rules, but not only in terms of jurisdictions, we also have conflict rules in terms of different sectors, sectoral regulation versus competition law. So it's a conundrum, and who knows better the way out of this labyrinth than you. You publish a lot on these issues and you are renowned experts. So I wanted to use this opportunity to invite you just to reflect upon this stuff. And maybe we can start with Or just reminding to us that these issues are not very new. We had the previous stage with Regulation 1/2003, and now we have the new dimension. Or please.
Yeah, thank you. So now I'm going to go in a bit of details of history of EU law and of the Regulation 1/2003. And many of this discussion is currently in a working paper that Magali and I have been working on called Article 3 of Regulation 1/2003, a historical and empirical account of an unworkable compromise, which you can find in SSRM. In this paper, we show that the tension between EU competition law and national laws is not new. It was already present actually when the Treaty of Rome was negotiated. Because it was such a sensitive question, so who can regulate markets and market participants, who can decide on the rules and who can enforce the rules, this was so sensitive that the member states just couldn't agree. And they agreed that in the treaty, that after 3 years after the treaty entered into force, they will come to a certain conclusion. But this never happened because it was so sensitive. However, up until 2004, while this matter was occasionally discussed by the European courts, the tension wasn't that pronounced because many of the member states did not have a competition law culture, maybe with the exception of Germany, and because of the nature of the enforcement. However, when Regulation 1/2003 entered into force in 2004, this brought this tension to the forefront. And Magali and I argue in the paper that this happened because of two main reasons, or two main aspects of the regulation. First, the regulation decentralized the enforcement. So while in the first 40 years of Regulation 1/2004, the Commission was the main body or main actor that could apply Article 101 and 102 and decide on what rules shall apply. Now, most of the enforcement happens by the member states. We know that around 85% of the enforcement is performed by national competition authorities that can apply not only their national competition rules, but in many cases, they're also in charge of applying sector regulations or other rules regulating markets. And then the tension between their national laws and EU competition law becomes more pronounced. The second element is that the regulation shifted from a prior notification system, where all agreements had to be notified to the Commission and assessed by the Commission, to a self-assessment system. That means that the Commission and national competition authorities can have the power to choose which cases to pursue and which to disregard. And for the purpose of our talk today, it also means that national competition authorities can choose not to apply competition rules and use their sector regulation or other national rules instead of competition. So those two challenges together increased the tension between EU competition law to other types of national laws and required a new solution. This new solution was codified by Article 3 of Regulation 1/2003. And if we try to summarize the solution very quickly, it looks something like Article 3.1 of the regulation enacts a principle of parallel application of EU and national competition laws. Probably going to talk about it a bit later. It obliges national competition authorities and national courts to apply Article 101 or 102 of the treaty if they apply their national competition laws. And of course, if there's effect between member states. Then Article 3.2 of the regulation sets a general principle of primacy of EU competition law, but then it provides for two exceptions. First, according to Article 3.2, member states are not prohibited from applying stricter national rules on unilateral conduct. That's parallel to Article 102. And according to Article 3.3 of the regulation, provisions of national law that predominantly pursue an objective different than what is pursued by Article 101 and 102 are also not precluded. The problem with Article 3, as we show in the paper, that it's drafted in a very convoluted way. Just to give a few examples, for example, the article does not tell us what stricter is. So what is the stricter national competition rules and unilateral conduct? Is it just stricter sanctions, like higher fines? In that case, probably it will not create many problems. Or does it also apply to national law that prohibit abuse, for example, by an undertaking that will not be considered dominant under the EU rules? So lower market share or limited degree of market power. Another set of challenges with regarding to Article 3 is just refers to what the objectives of Article 101 and 102 are. So the article tells us that if a rule pursues a predominantly different objectives, it will not be considered national competition law and could be applied. However, the regulation does not tell us what the objectives are. As we know, there is much debate for many years what the goals of EU competition law is or should be. So some argue that EU competition law is polycentric in nature. That means that in addition just to consumer welfare, it also protects things like fairness or more things about like sustainability or employment. And in that case, if you look at competition law as having very broad objective, that means that there will be many more national rules that might be in tension with EU competition law and might lose because of the primacy rule. Maybe finally, just to give this general overview, we also want to emphasize in the paper that the two exceptions of Article 3 are different in nature. So if you classify a rule as stricter national competition law, that's very different than if you classify it as pursuing a predominantly different objective. If we classify a national rule as stricter national competition law, a host of substantive, procedural, and institutional obligations kick in. For example, the National Competition Authority in such cases must apply Article 101 and 102, even if in the end the national rule is stricter. It will need to notify those proceedings to the ECN network, and the Commission has an opportunity to decide to take on the case and relieve the Competition Authority from its powers. This is true even if the national rule does not have a close equivalent in the treaty. For example, if we define competition law as something very broad. But this is true, and in that case, also the divergent national rule could only apply in the sense that the national rule is stricter and not just different than the rules in the EU treaties. This obligation does not apply if we classify the rule under Article 3.3 as pursuing a predominantly different objective.
Thank you very much, Or. It's really fascinating. And I can only imagine how the situation becomes even more complex with adding to this another dimension. Magali, may I ask you, how do you see, what do we inherit from the past when we talk about the digital regulation of digital markets, and how these old problems will, what implications would will have on this new regime?
So it's really interesting because when we look at Article 3 and the research we did, we see that one of the key things that we found fascinating was this idea of a predominantly different objective. And this is supposedly this distinction between the objectives of competition law and what is, not competition law. And in the DMA, I think this becomes more important because the DMA flips this on its head. It starts from a rule that is said not to be competition law and then establishes some conflict rules for other rules that are supposedly similar to the DMA and for rules that are competition law and have competition objectives. And we can go through the actual details of these conflict rules in the DMA later, but I find it particularly fascinating because of this similar logic that we see between Article 3 and the DMA. And in fact, when you saw the statements made by some national competition authorities during the drafting of the DMA, they explicitly said, can you please give us some room to adopt the rules that we currently have on our statute books And can you do that by using the logic of Article 3? And if you look at the DMA, that seems to be what happened. So there's a similar logic. The distinction between what is DMA and potential national rules that are similar to the DMA, and on the other hand, competition rules, is rooted in the objective of those laws. And our research on Article 3 shows that this is slightly problematic because, I mean, as we all know, what are the objectives of competition law is not so clear. But actually it is problematic in practice because if you look at some national practices, there isn't a coherent approach to what the objectives are of competition law and what the objectives are of other laws, such as those on unfair trading practices. Now, the DMA makes some improvements in that it's a bit more explicit about what the objectives are. So it says, you know, undistorted competition on the market. That's what we try to remedy with competition law. And on the other hand, the DMA goes for fairness and contestability. Despite being more explicit, though, we saw in our empirical research that there are some, you know, national cases where fairness is an element of competition law. And so if that's the case, then is that distinction actually as clear-cut as the DMA makes that? Other improvements are that the DMA says, okay, we know what the objectives are of competition law, but we also know that competition law is those rules that look at, you know, effects analysis and look at efficiency defenses. But although I think that's an improvement, I'm not entirely sure if in practice that's also such a clear distinction to make, and maybe we can have a talk about that. So why is this important? It might seem technical to people. They might say, well, in practice, you know, everybody's going to stay in their own lane and we're going to make sure that there is no conflict. It's one of the things when we looked at Article 3 that, you know, arguably you could say if everybody in their decentralized manner just decides to stick to cases of minor importance that aren't EU-wide importance, then although technically Article 3 doesn't work, maybe it doesn't matter. But I think it does matter. I think it matters for Article 3, but I think it matters particularly for the DMA, because we have seen national activity in digital markets. And in fact, Germany's change of its competition law rules to, you know, kind of do a DMA light version within competition law, it was in practice before the DMA was. And Germany's competition authority is enforcing its law. It's designating gatekeepers, and then it's gonna have to impose certain obligations. So there is definitely activity here. And I think the carve out that we see in the DMA for national competition rules comes exactly from Germany and France and the Netherlands, those countries that were also involved in the carve out that became Article 3. And so they have experience with adopting diverging laws, and they're very active in digital markets. I don't believe for a second that there isn't going to be conflicts. The question is how these are going to be resolved. Is the EU going to take a step back if Germany adopts certain obligations? Is Germany going to take a step back if the EU adopts certain obligations? We can have a debate about it, but I don't think the conflict rules in the DMA solve the problem. And I think there's going to be a lot of debate about the interpretation of the conflict rules. So either we're going to need a clearer interpretation of the conflict rules, or there's going to have to be some kind of diplomatic political agreement not to get in each other's way. Regardless, another point here is that these companies that are subject to the DMA have deep pockets, are very active, might want to litigate these things. And particularly if you see that Germany is talking about, you know, enabling private enforcement of the DMA, these things I think are going to come to the courts in some form or shape. So I think we might see more discussion about the DMA's conflict rules than we possibly do under Article 3. So that's just a broader background of why I think it might be even more problematic here than it was under Regulation 1 2003.
Thank you very much, Magali. Giorgio, if I can revert to you, you published on these issues and from various perspectives. Maybe we can leave the political dimension or the strategic elements for the future discussion. But I just wanted to ask your opinion. What do you think about what Or and Magali just highlighted, and maybe what more generally about the choice which have been ultimately the solution which have been ultimately agreed by co-legislators in the DMA? Is it an optimal one? Is it suboptimal? In what context? In what respect?
Okay. Yeah. Thank you for having me. So the first point, I guess, is when we look at Regulation 1, we talk about decentralized enforcement. Let's just be a little bit clear what that actually means. If you have a cartel that is present in 4 jurisdictions, you need 4 competition authorities to address it. So when a national competition authority applies EU competition law to a practice that has multi-territorial effects, it cannot solve it by itself. You see this, for example, in the Nordzucker judgment from last year, where the Austrian and the German authority ran a case against the cartel. And the concern was, am I overstepping my powers by imposing a penalty for conduct that occurs abroad, which I do not have? And EU law cannot confer on a national authority the power to apply its national laws extraterritorially. So if you think about it from that perspective, there is a logic in centralizing enforcement of the DMA at the Commission, because the German Competition Authority can scream and shout and do all sorts of aggressive things under Article 19A, but de jure, it can only enforce that within the confines of Germany. So a regulated firm to which Article 19A applies would only be bound by the German Competition Authority's obligations within the territory of Germany. So to a certain extent, while member states wanted more participation in the DMA, logically, this participation could never lead to one of the national competition authorities or a national authority specifically designed to enforce the DMA to apply the DMA with the same breadth as the Commission. So to a certain extent, centralization of DMA enforcement is necessary. I mean, just to give you an example, Booking.com, right? I mean, the commitments in Booking.com were made by all member states, and then some member states decided differently from others, but you could not have a single NCA regulate that platform. So either the Commission takes the case for the EU as a whole, or each member state does it. So to a certain extent, the centralizing is necessary. The other point to make, perhaps, and this goes to the controversial point that both Magali and Or mentioned, and why the conflict rule needs to be managed, is that suppose you have a firm which is regulated by the German rules and then decides, well, if the German rules are stricter than the DMA, I may as well adapt my business model across the EU as a whole. And so de facto, the German rules become the European rules. This is what Anne Bradford talked about when she spoke of the Brussels effect. So you have a toy manufacturer in Taiwan and they export their toys globally. What they'll do is they'll set the product standards to the strictest standards. Because the EU normally has the strictest standards, then the EU regulates the world. So here what we could be seeing is a domestic effect, an effect where a Paris effect, for example, if the French authority applies Article 102 or national laws in a way which is stricter than the DMA, that in a sense makes the national rules global. But that is a factual consideration, not a legal one. So I think centralization is relevant. The other point I'd like to make, however, is there may be conflicts, but there is a general duty of loyal cooperation, right? Article 4.3 on the Treaty of the European Union. So we can move to the political discussion later, but I think as a general principle, the DMA tries to embody a situation where, foreseeing the possibility of conflict, there are processes by which the conflict is managed. So conflict management, I think, should be read in 2 ways. One is a legal way. How do you manage the conflict between 2 rules in terms of which one takes priority? But there's also a more procedural manner of managing conflicts, which is how do we get the authorities together to sit down and ex-ante agree on the best way forward? And the DMA provides specific and more general ones. There's the high-level group, which provides general steering about different rules and how they coordinate. And then specifically within the application of competition law, there are processes for collaboration. And those may also help resolve some of these issues at a procedural level before we get to the substantive conflict.
Thank you, Giorgio. So let us now probably try to unravel these political elements. Or maybe while writing that paper with Magali, maybe you can remind us why it was so politicized, why the stakes were so high, and how these clashes have been transposed essentially to within Article 3 to the regime of the DMA.
Yeah, so what we see in the paper, I think, which is quite interesting, that almost in no point of the discussion did the Commission or member state thought of okay, this is the appropriate legal or economic test to resolve those conflicts. So there's no theory of law enforcement, no theory of decentralization, or before that of central enforcement. It's more a patchwork. And also the Court of Justice addressed it that way. So they looked at a few case-specific instances, tried to find the right solution, but there's no holistic or principle or framework to approach that. The Commission tried to change that with Regulation 1/2003. So what Magali and I did in the paper is to look at the history of the negotiations over the regulation. So to see why this weird Article 3 wording came into being. And what we saw that in the beginning of the negotiations, the Commission advocated quite fiercely for completely different solutions. So according to the original version of Article 3, and I'm citing now, when Article 101 or 102 can apply, they will apply to the exclusion of national competition laws when the practice has an effect on trade between member states. So if the Commission original proposal would have been adopted, that means that when Article 101 and 102 apply, there is no longer any room for conflicting national law. The Commission defended that, saying that parallel application of EU and national laws will lead to divergence and to unnecessarily parallel proceedings, which will hamper the whole idea of the internal market. While the Commission was fierce in these positions, the member states were equally fierce in opposite this approach. So the member states believed that they should retain the power to decide what kind of laws apply and to have their own traditions on regulation of markets and unfair trading practices. This point, the conflict of laws, was actually one of the most difficult part of the whole negotiation procedure. What we see that because it was so contentious, the Commission's original proposing, saying that Article 101 and 102 will apply to the exclusion of national competition laws, was left up until the end of the negotiation procedures. For the first 2 years of the negotiations, this was the rule in the draft regulation. Only in the last month, the Commission and member states came to a compromise. And the word political compromise is in the negotiation procedure. So it was quite clear that we are not talking about a coherent legal or economic framework, but just a way that the member states will come to an agreement. Article 3.2, allowing for stricter national competition law, was a way to satisfy the German concerns for their national abuse of dominance rules. And Article 3.3, allowing for unfair trading practices, was a way to settle the opposition from the French. And we can see that a very similar tension and very similar political discussion also happens with the DMA. So again, there's no clear, coherent thinking of why we need that, but more of just a way to come to an agreement, to allow to adopting a regulation or procedure.
Magali, maybe it's probably a good time for us to just remind ourselves how this conflict of laws is envisaged in the DMA. So we have two provisions, two paragraphs. Can you highlight the rationale? And maybe you can also reflect whether it's actually possible. Is there any kind of ideal benchmark or maybe a better one in your view?
Is there an ideal benchmark? I'll explain what is happening in Article 1 and then see if I can come up with an answer to that. But the Article 1 of the DMA is basically where you see some Article 3 of Regulation 1/2003 inspired kind of similar conflict rule. But it's also important as a side note to read the recitals. One of the things though that we also saw in our paper on Article 3 is that you need to read the recitals to understand some stuff, but sometimes in Regulation 1/2003 there's a conflict between the recitals and the text of Article 3, which luckily the DMA seems not to do. So I'm very proud of the drafters of the DMA. That's an improvement. But you need to read Article 1 and you need to also, I think, look at the recitals, although we all know recitals don't have the same binding force. But in this case, they're very important. So Article 1 has two elements to it. So in Article 1.5, the DMA basically tells you what the rule is for a conflict between the DMA and potential national rules that are similar to the DMA, so that might regulate digital platforms. And then Article 1.6 looks at the relationship between the DMA and national competition rules. Also EU competition law, but for our purposes, the national competition law one is the most interesting. So in Article 1.5, there is this general idea of primacy of the DMA. So where a member state wants to regulate digital platforms, it says in the DMA, look, the DMA is here the key enforcement system for gatekeepers in ensuring contestability and fairness in markets that have gatekeepers. And this is really crucial because it then says member states are prohibited from adopting not just other laws, but also administrative measures that are designed to ensure contestability and fairness for gatekeepers. In understanding this rule, though, you have to understand that the key thing here is the objective. So the contestability and fairness element is extremely important, because if a law at national level or a measure at national level isn't about contestability and fairness, then it can still be adopted. Also, the DMA adds that it's possible to adopt kind of measures that aren't adopted because it's about gatekeepers in the meaning of the DMA. I don't want to spend too much time on that because I think a lot of this hinges on how we interpret gatekeepers, if that's significantly different from, for example, in Germany, this a paramount significance across markets idea. I think the key thing that we found interesting was really the objective of contestability and fairness is a key differentiating factor between the DMA and possible rules adopted at national level. This is also interesting because a similar logic is adopted for Article 1.6. So here, in terms of conflict between the DMA and national competition rules, on the other hand, the DMA says, well, competition law is significantly different. It has a, in the wording of Article 3, predominantly different objective. Namely, it is trying to fight on, issues that might distort competition on the market. Whereas, says the DMA, contestability and fairness are objectives of non-competition rules like the DMA. This is more explicit than what you see in Article 3 of Regulation 1/2003, although Regulation 1/2003 does, in the recitals, give examples of fairness as an element that puts a law outside of the scope of competition law. But here it's far more explicit, right? So fairness and contestability is not competition law. Competition law is about undistorted competition on the market. I then think this is really interesting because when we look at our research in Article 3, this doesn't really work at a national level, because it's actually not that easy to say that, competition law is about competition on the market versus non-competition rules are about some kind of more individualized interests or fairness, or however you want to interpret that. Because in some member states, actually, these objectives are looked at as a whole throughout both competition law and non-competition rules. And there might be multiple objectives in one particular case, in one particular provision. So that's quite difficult. But in defense of the DMA does say, another distinguishing factor between competition rules and the DMA is that competition law requires this kind of case-by-case assessment of market position, of effects, of efficiency or objective justifications. I think this is an improvement, but I'm also kind of skeptical about this because I'm not sure, the extent to which this is such an easy thing to differentiate for two reasons. The first being that in our research, we saw that effects analysis is also not very consistent in national practice in terms of what kind of harm is considered. But more importantly, I think, because this assumes that the DMA is wholly per se and static. And I think this is a reasonable assumption because one of the arguments for adopting the DMA was, this effects analysis, market definition, justifications, all of this takes a lot of time. And it's better to start without these things, just assume we already know what the harm is and impose obligations as a result of that. But if you look at the discussions now on the workshops on how to interpret these obligations, I'm getting a feeling, and I might be wrong, but I'm getting a feeling that there is more of an effects analysis again, that there's more of a case-by-case assessment of how these obligations would work for the specific companies that are gatekeepers. So my question is, the extent to which this is a legalistic, formalistic interpretation of that dimension, in which case maybe this is all we need and the objectives is just irrelevant. But if it's more practical and you look actually at what happens, I'm not sure the DMA will not require any kind of individualized assessment. And on the flip side, the German law, which is competition law, has kind of reduced its effects assessment and flipped the burden. If we end up in a judicial review and that judicial review of the DMA does require some kind of effects analysis, where does that put us in that kind of conflict rule? So I guess in a nutshell, we in our paper look at 3 possible benchmarks of the objectives, of the harm, and we conclude that, you know, the harm might be an interesting one, but in practice, none of these benchmarks are actually consistently applied throughout national practice. When it comes to the DMA tries to integrate the objectives, which I'm not sure is going to work, tries to create an improvement, I think, with adding this element of effects analysis, but I think that only works if the DMA stays strictly per se, and I'm not sure if that's the case.
Giorgio, from your experience and your deep expertise in these issues, can you try to engage in this unwelcoming endeavor and try to imagine the future in a couple of years? Do you think it will be very litigious? And we know that the stakes are so high and stakeholders are so diverse. So how can we anticipate the evolution of these provisions in reality?
Yeah, well, I guess maybe it's worth putting some flesh on the bones. So we have now seen that there's potentially a conflict, right? So let's maybe give an example. So suppose, the DMA prohibits self-preferencing, but what if the Germans say, no, we want to actively require you to give preference to others. So not preferencing yourself, but preferencing others. So the first page of search results shall all be undertakings which are not the dominant firm, right? So here you have a situation where you may say, okay, for the purposes of applying competition law, I'm not so interested in that discussion for now, but let's just give an example of a situation where the DMA sets an obligation and the national law says, I want you to do more on the basis of my national competition law. Now, is that necessarily a problem? Well, it's a problem if you think there should be a one-stop shop regulation for gatekeepers and harmonization. So to a certain extent, the whole basis of this regulation is 114, let's harmonize. And then you, in effect, I mean, the rules that Magali explained do not prevent the creation of a mini DMA. You can phrase it differently. Okay, I'm going to regulate the search engine, not because it's a gatekeeper, but because it's an important pathway. And then I'm going to put an obligation, which is very similar to what is in the DMA, but it's phrased slightly differently. So it's very easy for a member state to circumvent the harmonization rule and effectively do more. The question is whether we have a problem with that. As I said before, the believers of harmonization would cry and say, oh, this is a major problem, but maybe it's an opportunity. It's an opportunity. So Bernardo Rangoni and I have done a couple of papers on experimentalism in competition law. We've shown that there is little attempt by the national competition authorities to experiment in the application of competition policy, but this is something that could come out of this. So if indeed one national competition authority opts for stricter rules, and then we can observe whether those stricter rules work better. And what you can then have is you could have these different rules being reviewed after a while and then review the DMA. So in a sense, divergence may not necessarily be so problematic in the long term. That may be one way of thinking about it. But as I said before, obviously, the national authorities also will cooperate with the Commission. And so I think we need to be conscious of the fact that in their cooperation, the authorities will also be aware, as you said, of firms being litigious. And so they should really try to avoid undermining each other's enforcement efforts. So if you have one national authority that says, I do not believe that this firm is a gatekeeper, that's not the sort of language you would want to see because it would undermine the application of the DMA. But one thing worth bearing in mind is that, in my experience, the active national competition authorities and the active member states are working on the basis of let's regulate tech markets even more strictly than the DMA. So we don't have a conflict between jurisdictions where we have one authority which is saying let's have less enforcement. So to a certain extent, both the Commission and the national agencies are all more or less motivated by the same objective, whatever you phrase it, contestability, fairness, competition. But the objective is to regulate tech more extensively. So to that extent, that also minimizes a little bit the risk of a conflict, because the greatest conflict you're going to have, as with the example I've given you, is where the national imposes additional obligations too. But I don't think you'd ever have a situation where the national would say less obligations are needed. Just maybe one quick response to Magali. I completely agree with you that the DMA is an effects-based approach, because ultimately the compliance report that the gatekeeper has to produce has to show how it effectively delivers on contestability and fairness. So necessarily somebody is going to have to prove, and I think what's interesting in the DMA, the burden of proof is on the undertaking, because the gatekeeper has to show that these mechanisms deliver the objectives of the DMA. And if that's not an effects-based analysis, I don't know what it is.
And do you think this effect-based analysis is justiciable?
Yeah, difficult question. Well, to a certain extent, put it this way, the compliance report has to provide elements that allow the Commission to evaluate whether there has been compliance. Suppose the Commission disagrees, there is no compliance. Then obviously, ultimately, if a decision is rendered by the Commission saying we do not believe you've done sufficient work to comply, then that decision of the Commission would be justiciable. And then indirectly, the General Court would be reviewing whether or not what the undertaking has done is satisfactory.
Thank you very much, Giorgio. So maybe let us try to continue with this attempt to imagine how far we can, the stakeholders can go with imposing further obligations on undertakings, which are coincidentally designated with the status of gatekeeper. I mean, by stakeholders, I obviously mean member states. Or what do you think on it?
Yeah, so I mean, very hard to try to predict. I think if we look at the example of Article 3, as we show empirically by looking at the example of France and Germany, member states can go quite far. So we saw in the example of those two member states that member states adopted quite approaches that differ from one another, what they see as competition law. And even within one jurisdiction, sometimes national competition authorities and national courts interpret similar provisions or the same provisions as being different. So if we try to apply the same logic to the DMA, we would say, yeah, probably they could go quite far. On the other hand, and going back to what Magali and Giorgio already mentioned, this flexibility is probably also originate from the fact that the case is not being that this issue is not being litigated much in the EU level. So when it comes to competition law, we can assume that in many cases, both the undertakings and the national competition authorities have some incentives to try to, that they will be happy to classify it as national competition law, and not to contest the primacy of EU competition law. We know that EU competition law comes with very high sanctions, with the threat that the matter will be litigated in private enforcement or will be litigated in other jurisdictions in the EU, and therefore it could be, and with a lot of procedural and substantive obligations from the competition authority, for example. So both sides might have the interest of just keeping it quiet at the national level. This probably will not apply when it comes to the DMA. So we're talking about gatekeepers, deep pockets, and very strong incentives to try to contest the question of whether those additional obligations in national level could still apply. The same is true with the member states, because it seems that some member states are quite keen to continue and adopt rules, continue and enforce. They are also likely to challenge a position according to which those further obligations are not complicit with the DMA. So I think if I would have to guess, probably we'll have an answer about the limits of the DMA first, and maybe the DMA will inform later the boundaries of Article 3 in a bit of a weird outcome.
Thank you. Magali, I think some commentators, I recollect Julian Novak mentioning quite recently that the gatekeepers would at least hypothetically, have an opportunity to question the validity of any national law which has any implications to the issues of fairness or contestability. And those are so open-ended concepts, which is not pathological as we understand. It's a norm, but it's a challenge essentially. How do you see this? Do you think they will be very creative and opportunistic maybe in trying to infer the fairness and contestability from pretty much any national law?
So a bit of a glib answer to that is that if I had that kind of money, I definitely would try to get as much of this challenged, because, well, out of just general curiosity where it would go, but also because I don't, I see it as in their interest to litigate these things. However, I think this really is something that we will have to see in practice, what the interests are of the gatekeepers. They're also all quite different in their relation with the authorities. So I think that really is factual, and I'm not a betting person, so I'm not going to put too much money on it. However, I think there is something to the question of whether Article 1.5 and its reference to fairness and contestability as objectives of the DMA actually is problematic, because anything can be about fairness and contestability. I think in theory that's true. In theory, you could say there are plenty of national rules that have some kind of impact on fairness and contestability. Therefore, Article 1.5 excludes many of these rules. But there are two caveats to that. First, that it is not just the objective of fairness and contestability, but also this gatekeeper notion that has to somehow be related to these national rules. And I think a second one really goes to these kind of benchmarks for differentiating one rule from another. How are you going to interpret the objectives? Are you going to say it is about the objectives or as they are stated by the legislator or as they are described by the courts? Or is it you're going to look at the effects analysis, the harm in a particular case, and deduce the objectives of the law from that? If that's kind of the approach, we really want some kind of strong evidence that fairness and contestability are objectives of this national rule, then I think there might be problems, but I think they will be limited to those laws where you can see either fairness and contestability as a direct objective or a direct consideration in the effects analysis. I don't think, and here I'm trying to give everybody as much credit as possible, I don't think anyone is going to go after laws that might have a side effect of fairness and contestability, because let's be honest, all laws have a side effect on fairness because it depends on how you interpret fairness. I think it would be, what's the right word here? I think it would be kind of unjust and unreasonable to go after laws because they have some kind of indirect effect on fairness. When it comes to contestability, I think that's a broader issue, because obviously contestability has a clearer relationship with competition law and might be more distinct as a concept. And so there, I think there might be a bigger risk that we've got laws that are about contestability, that are somehow conflicting with the DMA. But I do want to give credit to the authorities. I think this is going to be a problem only where fairness and contestability is a conscious objective or a conscious consideration in the effects analysis rather than a side consideration. But then maybe I'm giving too much credit, and Julian might be more pessimistic, but also realistic than I am. But really, this is a factual question. But I think it goes to the point that this wording is ambiguous, that we're using these concepts of contestability and fairness as if we are all agreed on what they mean. And I don't think that's true. I don't think if you put 10 competition lawyers and 10 non-competition lawyers in a room, not only will the non-competition lawyers and the competition lawyers not agree, the competition lawyers won't agree amongst each other. I did a 2-hour session in my advanced class on competition law and asked people what fairness was, and none of them could give me the same definition. And none could tell me what contestability was in the same way. So I think it's problematic to use concepts when we don't know what they mean. But I always think that's problematic.
Giorgio, what is your opinion on this? Do you have you are more optimistic, I think, than those who try to somehow to predict the cascade of confusion coming from the adoption or entering into force of this new ideology?
Well, I guess maybe let's start with something small. Take the B-post judgment of the Court of Justice last year. There was about the postal regulation and competition. Are they pursuing the same objective or different objective? And they say different. Okay, that's interesting, because I'd always thought that you could say on the basis of the breadth of 102 that they're actually the same, right? Because they're both about opening markets. So the court appears to recognize a different space for sector regulation, which is different than the space for competition policy. So that makes me optimistic, because the court also creates a process whereby it suggests, okay, so even if the two are the same, then here is how you manage the relationship between the rules through some sort of process. But the primary point the court makes, and without much reflection, it doesn't elaborate very much, is, oh, look, postal regulation is not the same as competition policy. So from that perspective, this idea of, I mean, I agree with Magali, I mean, to a certain extent, obviously, many rules will deal with fairness. I mean, is there a law which is deliberately unfair? So to a certain extent, you can't say any rule of national law is illegal, contrary to the DMA, because it pursues fairness to some extent. I mean, you've got to have a little more substance in that, but B-post makes me optimistic. And so that's one reflection. The other is how much latitude, so if these cases are litigated, how much will the court actually engage in this discussion, and how willing will they be to pin the DMA down? As you said, you said before, you know, fairness and contestability are fairly open-ended norms. The recitals try to define it in a way which is much more granular than it was at the beginning of the proposal, but it's clear that the Commission itself doesn't know what fairness and contestability are or what they want to achieve. So one of the things that I think should be discussed is what should the DMA make these markets look like, because that will give us a better sense of what we understand by fairness and contestability. And so to a certain extent, it's a bit hard for the courts to then say something about, is this national law incompatible with the DMA because it functions in a way which is so similar? I think it's a very difficult thing for the ECJ to handle, and I guess they will try to avoid answering that question directly. It has never engaged directly with the question of what happens when there are different aims, except in situations in internal market law where you run a non-market argument against a market argument. So when the Scottish government increased the price of alcohol, then it says, okay, public health versus internal market. I can see that public health is a different objective from the objective of regulating markets for the benefit of consumers, even though there you can say both are trying to protect the consumer, because the higher prices are designed to protect the vulnerable consumer who's alcoholic from buying less alcohol. So, but in these very obvious cases where the national rule and the European rules pursue similar, but we know, we don't have the language to express this clearly, or I don't have the language to express it. It's pretty obvious that one is a non-market consumer protection objective, whereas the internal market rules are more market-based objectives, that there the courts are quite able to say something substantively. But when it comes to these areas where DMA versus German competition policy, I'm not so sure the court will ever engage in a discussion as to whether or not national law is legitimate.
Or we know that, again, we started this conversation with reference that the history is magistra vita, yes. So we know that some of the structure of the problems can be somehow traced back in history. And you, together with Magali, did an empirical study where you basically try to explore this different approaches of some national competition authorities to this strictness, yeah, the stricter competition, stricter rules on unilateral conduct. What are the findings, and how can we somehow implement those conclusions to the current situation?
Yeah, so same paper, second part. In that paper, so we started with the history, and we show that the history does not give us a decisive benchmark or decisive guidance on how to go about and say what is stricter national competition law as opposed, for example, to either non-stricter national competition law or just a law that pursues a predominantly different objective. What we did in the second part of the paper is, because there's no such benchmark, we tried to look still at the legislative history, at the wording of Article 3 and the regulation, and how the EU courts case law went about it, and some of the Commission's policy paper, to try to first identify possible benchmark, discuss the impact, and see if we can see some trend emerging in national practice. So the benchmarks, we identified 3 possible benchmarks. One would be that we will decide what is stricter national competition law, so what is stricter and what is competition law, based on the objective of the national status. So if we have a national status that is part of competition law, and the rule is inside that, we will say, okay, this is competition law rather than a national or pursuing a predominantly different objective. This benchmark, of course, is quite formalistic in nature, quite easy to circumvent. On the other hand, because of the same reason, it's quite clear and predictable. The second possible benchmark is not looking at the objective of the statute as such, but of the specific national provision. So to try to look at its history, why it was added to national law, and how it's been interpreted. The third possible benchmark is to look at the harm addressed in the enforcement of this provision. So how national competition authorities and how national courts actually applied the harm, looking at the different elements and what they identified. This third benchmark is effect-based and perhaps is more compliant with the effect-based approach of competition law. On the other hand, it provides very low legal certainty because it will be case-dependent and might also change throughout time. So we can see that each one of those benchmarks represent a trade-off between formalistic and effect-based, between legal certainty, and also between uniformity and providing more room for national interpretations and national practices. What we thought to do in this paper is to look only at 2 member states. So we looked at Germany and France and how they applied Article 3 and how they also interpreted the aims under each one of the 3 benchmarks of their national competition rules and other rules on unfair trading practices or abuse of economic dependence, for example. What we found in the paper that none of the 3 possible benchmarks guided the practice, the national practice. Those benchmarks not only not guided did not guide both countries, it even not guided the practice of each one of the countries. So for example, we see both in France and in Germany, the different courts or different competition authorities interpret the same rule or similar rules differently. Often they invoke a host of objectives. So, I mean, as Magali and Giorgio already mentioned, in addition to just competition, we also talk about protection of consumers, protection of small competitors, fairness is always a big one, and so on. So again, I think we are quite pessimistic when it comes to the possibility of national practice to try to give meaning or to lead to uniformity when it comes to very open-ended provision like Article 3 of the regulation or Article 5 and 6 of the DMA.
And maybe as a follow-on question to Magali, you showed to us how important the stakes were and how diverse the views were in this political discussion. Now we realized, witnessing over the last few years, that's kind of, in my view, unprecedented emotional kind of engagement and polarized approach to the matter. We still have managed, and with 27 member states, and more complex legislative process, well, complexes in both directions. Maybe it's more flexible, maybe it's part of the answer, but still we managed to find a compromise. What is this golden core which enabled ultimately to find a compromise, even acknowledging that all these complexities which you have so convincingly presented in your 2 papers, actually, on one on the DMA and one on 2003.
What helped them find a compromise? I mean, I think a lot of this depends on having been there and having followed every single conversation. But I think something Giorgio mentioned earlier is that in actual fact, I think most member states are of the same view that it was time to do something. right? They had similar misgivings about how the enforcement of competition law was going in digital markets. So I think when you have a starting point, the similar willingness to move forward, then you're going to be more likely to find a compromise. That being said, I think there were significant divergences in what they thought this was going to look like. Now we're in the UK, which is no longer a member state. I'll leave aside how we feel about that. But just if you look at the way the UK was debating it, and Germany was debating it, and France was using its abuse of economic dependence rules in this field, you saw diverging views on how we had to go after the power of big tech or digital platforms, or whatever you want to call it. So I think in a way it is surprising that we got here so fast and we did reach a compromise. And I think that that's something that merits some kind of, congratulations. But then the question is what the compromise looks like, and who has won, who has lost. I think when you look at the DMA, I am not sure who got what they wanted. I mean, the European Commission clearly wanted centralization, and I think that was the right call. I don't think, like Giorgio, I don't think you could have done this in a less centralized manner and still have reasonable outcomes. But the member states clearly wanted more involvement. They have gotten some carve-outs though, and I think the room for national competition rules and for other rules which, if they don't pursue contestability and fairness and they don't go after gatekeepers in the meaning of the DMA, is a carve-out in favor of the member states. So I think everybody got something here. Did they get as much as they wanted? I mean, I know that some competition authorities wanted a much more significant involvement in the enforcement of the DMA, but they didn't get that. But all of this will depend on how the DMA is enforced, how much the European Commission brings in the authorities in its discussions about the DMA, but also whether in this investigative power that the competition authorities do have, whether they actually use that. Will they just rely on the carve-outs to use their own revised competition laws or their new rules to just do their own national actions? In that case, I think there won't be that much relevance to this investigative power they've been given. And I think that might be a shame, especially because there was such negotiation about the role of the member states. So I think, why was there a political compromise? Because these things always lead to political compromise. Is it a good compromise? Will depend on how this is enforced in practice and how the member states use the power that they have been given. And I am not sure about that, if I'm honest. My feeling is this really depends from one member state to another. I don't think anybody will be surprised if we say the German authority is going to try to be involved as much as possible in this field. Is that the same for all authorities? I'm not sure that's the case. So I'm not sure the European Commission got exactly what it wanted, neither did the member states. What is entirely impressive is how fast it went. Whether that speed in adopting the DMA is a good thing or a bad thing really depends on your criteria for judging the DMA by, but it is impressive nonetheless. And I think when Or summarized the findings of our empirical paper, I think it is particularly important to remember that we didn't see consistency in practice at national level. So if the member states do their own things and don't use their investigative power to help the DMA, but use it predominantly for their own rules, that could lead to really interesting experimental outcomes, but it probably won't help the DMA much further. But maybe that's not the best way to regulate these platforms. Maybe experimentalism is the best, although I go back and forth on this, Giorgio. I think it really depends on your criteria for judging experiments by. And 1 month I'm all in favor, and the other month I think, oh no, this is going to be a disaster. So I might be less optimistic there.
Thank you, Magali. Giorgio, you mentioned experimentalism, and Magali just mentioned it as well. Of course, one approach would be to say that leaving the room for private enforcement would increase the opportunity to experiment, because we'll have different incentives, and who knows better how to interpret the provisions of the DMA than those who are affected. On the other hand, we pretty much hear almost consensual agreement that centralization is necessary. We call it harmonization, maybe, or it's just about centralized enforcement, but it's pretty much inevitable requirement for the effective functioning of digital markets. So why do you think there was, and actually there is a deliberate choice, at least as far as collective action concerns in the DMA, which opened this door? Do you think there was an opportunity not to open the door, to make the directly applicable provisions not directly effective, or there is more kind of, so there was no second choice for the legislators, or it's done on purpose? And if it's done on purpose, how can we square it with the previous kind of narrative about centralization?
Thanks. Yeah, I guess one might have tried to design a regulation which didn't have direct applicability, but it would have looked very different. It would have looked exactly a bit like the UK model of let's get one agency to discretionarily review a designated firm and monitor its conduct and supervise it for the next 10 years or something like that. Then maybe you would have got rid of the capacity to apply these rules at national level in the courts. But that was never on the cards, and I think for the reasons Magali kind of hinted at, we don't want to replicate the competition rules, and we want per se legalities and no objective justification, and the pretense of a per se rule was dominating, and so necessarily then you drafted something which by EU law had direct effect. But there's another issue which maybe is deeper, which is ever since the beginning, the EU has believed in private litigation as being necessary to the functioning of the internal market. So if you go back to Van Henden laws, why do we have private enforcement? Because the private attorneys general make the EU work. Frankovic, same. Courage and Crehan copies and pastes the Frankovic judgment. So basically every time there was a question, should private litigants have a space to play in the EU regulatory space? The answer is of course, because that complements the EU rules. And I think it's interesting to observe why that has been the case historically. And this is because from the beginning, EU law generally is enforced in a decentralized manner, right? Most of EU law is directives. Member states shall implement a directive. Member states shall enforce EU rules in their various legal orders. And one way of sort of countering the disobedient state who doesn't implement a directive, or a slow state who doesn't apply the rules robustly, is to have the private litigant do this. So we have generations of EU lawyers trained on the fact that private enforcement is necessary to actually have EU law work. Now, are we reaching an end of this period? Because if we are going to regulate digital markets in a comprehensive manner, we need EU regulators. So what we're trying to do here is a little bit within the current competences that we have, whereby we cannot create an EU regulator. So one of the things is, who got more power, the Commission or the member states? One of the problems is, however much power the Commission has, if it doesn't have the capacity to exercise this power, it's never really actually going to be able to do anything useful. So yes, there's a recruitment drive and there will be more people, but they will always be outnumbered by the financial and other resources of the gatekeepers. So it is maybe time to reflect upon whether, rather than going on the mood that let's keep private enforcement as a necessary complement to make EU law work, whether we actually need to rethink the institutional dimension of the EU and say it's not the Commission who should apply competition law or the DMA, but we should have regulators. And of course, from the early days, this is difficult because the Commission cannot delegate powers, but maybe that's a reflection for the longer term, whether we want transnational regulatory bodies. It has strengths and weaknesses, but that might be a mechanism that we haven't really thought about. Just one quick reflection on what will member states do. Will they apply their national rules, or will they help the Commission? There's no incentive to help the Commission enforce the DMA. What reward are you going to get? You're not going to get more resources from your member state because you're helping the Commission apply the DMA. So of course, the incentive is all to apply the new rules that have just been given to you and to also test their limits. Maybe one point to reflect on this, which is in a different direction, so I haven't prepared on it, but suppose you do have national agencies applying different rules from the DMA. But that may still take away the experimentalism issue. and even consider the rules that Magali and Or discussed in Germany and France. Okay, maybe they have inconsistencies and incoherences and so on and so forth. But all these rules do, to a certain extent, aim to make markets work better. So to a certain extent, the fact that we have more than one person regulating markets may well make markets work better than if we had nobody regulating. So yes, we can feel that maybe there are some cases of conflict, but maybe there aren't as many conflictual cases as we see. And even if there are slight differences overall, the more we regulate markets, the better off we are, to a certain extent.
That sounds really reassuring. Before reverting to the most interesting part of our conversation, when I ask your recommendations to students, I wanted to ask Or and Magali if you have your reflections on the latest things articulated by Giorgio.
Can I start, Magali? So explore a thought about private enforcement. I think private enforcement, when we talk about law enforcement theory, not necessarily competition law, DMA, private enforcement has also a really important role of checking the functioning of authorities and fighting capture. And I think that regulatory capture is such a big issue when it comes to gatekeepers and those big companies. I mean, so of course, there are huge companies that have very strong political influence, both on the member states and in the enforcement. We see many revolving door practices of the same people go in and out those forms. And private enforcement is a way to check the enforcement priorities and enforcement practice of the competition authorities and the commission. And for me, this is a very important element that we should not disregard. Yeah.
I mean, when Giorgio was talking about this move back, I was actually, so this is just I'm thinking about it out loud. So to me, Van laws, free movement cases, earlier competition law cases, there is an inherent logic to allowing private enforcement, and I think Giorgio is entirely right there. I think this question of whether we have to move back when it comes to having digital regulation really again goes to what we're trying to achieve. And I know the question of the objectives of law is worn out, and we all talk about it and we never agree. But to me, private enforcement inherently makes sense and is a good addition when we believe that in addition to protecting some kind of collective interest, there are individuals here that are harmed. When we look at the DMA and digital regulation more broadly, I am not entirely sure whether there are specific interest groups who are harmed and who we're wanting to protect. My feeling is that there is a more collective view of making markets work better, and indirectly these may benefit, other companies, they may benefit consumers and so on, but I don't think that should be the key objective here. And if your key objective is a more, collective idea of a market or a collective idea, then I think private enforcement kind of undermines that, because you'll get different approaches that focus on the damage to an individual group. So if we all accept, actually it's about particular interests and SMEs are who we want to protect, then maybe private enforcement is the way to go. But I am not sure we were agreed on that. In fact, I think quite the opposite. We're still trying to, put forward the idea that there is some kind of collective that we are protecting. And then I'm not sure private enforcement helps us very much. But that's just a side note that I was thinking about. And I think in free movement cases, it is evident that private enforcement is the way to go, because it is one individual's interest in moving. And then collectively that helps the EU as a whole, but we are focusing on an individual interest. Here with the DMA, whose individual interest is it that we are protecting? I would be very, very concerned if that's where we're going with the DMA. But that was just an aside.
I'm afraid students who are eager to learn your recommendations have to wait a few more minutes, because I think this issue merits another round, if maybe very quick. So Giorgio, how do you reflect upon those who say that, well, we were concerned about the scope of 102, but then the DMA extended even further in terms of encroachment of individual liberty and freedom of contract to basically to benefit from the fruits of you being the best on the market, however you achieve this position. So we go further, much further, with 20 obligations or so. And the only explanation for this is that it has to be applied selectively for the benefits of shaping, calibrating the digital markets, and by single enforcement. If you open it to this open-ended provision to very smart private litigants, we will somehow paralyze the markets. Does it make sense, this kind of rationale? I paraphrase what you've said, Magali, or maybe add to what you have said. Or is it purely hypothetical concern?
Yeah, I wonder. I found that Magali's comment really stimulating, because I never thought about it from that perspective. But because normally when an individual makes a claim under EU law, they have to, of course, say there's a harm to me, but there's also harm to the market. The rules hamper the free movement of goods. By hampering the free movement of goods, I am harmed. The rules harm competition. By harming competition, I am harmed. So there's always a collective interest that you have to demonstrate before you're able to hook your own case. You cannot just say I am harmed without that harm being also a collective harm, which is why the individual is a private attorney general. He's claiming for his interests, but his or her interests are representative of a broader class. So I'm not so sure that, that there is this risk of the sort of individuals selectively, strategically using the DMA to protect an interest which they can achieve without demonstrating a more collective interest. The risk I see maybe is related but different, which is the individual strategically using the DMA to protect their interest, and that nuisance value itself raises the costs of the rival, right? So it's not so much whether the claim is valid or not, but an invalid claim. So suppose you have a firm which is a gatekeeper in market A and wants to enter market B, and then uses its economic power to leverage some litigation that favors it, then I think the risk can be problematic. And I think the safeguard that even this gatekeeper has to demonstrate a public interest harm in market B still can create a lot of nuisance in terms of, 6 or 7 years of litigation whereby things are unsettled and can therefore raise the costs of the other gatekeepers. So I think gatekeeper versus gatekeeper litigation might be raise the problems that Magali raises and problematize the DMA even further.
Or Magali, some last minute reflections on the substance. In this case, let me revert to you and ask for some recommendation, maybe not necessarily recommendations like focus on digital or don't do digital because it's so pervasive, or maybe some life hacks about how do you do with your time management. So much is going on, how you can read all these issues, how do you select, maybe how do you deal with your work rest balance, etc., and maybe also suggesting some tips for promising topics for research on focus. Or please.
I'm sorry. Oh, okay. I think, okay, let's do empirical research, because I think that's a nice part of the paper that we like. So I think one of my recommendations for students is trying to be systematic when looking at cases. And I think this paper for me in Magali was quite a good example. So there have been some papers about Article 3 and its problems before, not many, but some. But what we enjoyed in this paper is trying to look actually at practice and we didn't look at a huge amount of cases, but still looking how the issue is being examined in different cases in 2 member states. And I think thinking about coding the cases and trying to look at a relatively nice body of cases systematically, we were able to flesh out some of the challenges of Article 3 and also of the DMA, and to kind of have proof to contest some of the Commission's claim or some of the claim of the legislative process. And I think that this is something that students can do even with dissertations or relatively smaller research papers. I think just choosing the cases based on a robust selection criteria and trying to analyze them systematically can enhance your research and allow you to bring new perspectives to things that have been examined before quite nicely. In terms of time management, another thing would be just to have a to-read list. and to maybe carve out every week or every day a selected time where you just go through your reading list and try to read it, especially on things you're not working on. I find useful, because things you work on, you don't really do find the time.
Thank you very much, Magali.
Yeah, so time management. I mean, time management is my colleagues and my PhD students would know it's like my key thing that I obsess about, and I tell them to obsess about. Mostly I'm the kind of person that uses like 500 different solutions to then end up on one, because I found that the biggest struggle of being an academic, but doing any kind of academic work, even as a student, is to kind of know how much time things will take and have a way of tracking how much time you're spending on things. I used to, and sometimes still do, severely underestimate how much time things will take, and then I get annoyed at myself. So, I mean, people who know me will know that my calendar is color-coded. I have a OneNote with a to-do list, and I write behind it, actually, I said it was going to take an hour, and it took me 5, which happens sometimes. And I'm obsessive about it, to the point where I think my PhD students are getting kind of sick and tired of me telling them how much time did it take. But I think it's important. You'll never be able to do everything you want to do. This is the reality. And particularly when it comes to keeping track of things, it's really hard to keep track of everything that comes out academically. So you need to have some kind of rules of thumb for how you're going to select things. And actually, I think having a to-do reading list is a good idea. I want to say one of the problems I see is that we're becoming more and more subject specialists within a very narrow subset of our subjects. And so, you know, not only are you a computational academic, you look at one or two, and not only do you look at one or two, you look at a particular type of abuse, or I don't know. As a result, nobody knows anything about the basics, and that's problematic. So really good academics, the ones that impress me, are the ones that read widely. And that decide, you know, this is all the stuff I need to read for my topic, but today I'm going to spend 2 hours looking at other things, and not just computational, you know, reading economic books or even pop culture, or I don't know. I'm obsessed with Carlo Rovelli. I read all his stuff. And so I think that's really helpful. But the reality is you can't do it all. So you have to decide what is important for you. And as a student, that's hard. And if you're already struggling, it's going to get harder. So now you have the time of luxury to try to figure out some rules and methods to do that. And yeah, I mean, I think time management I was laughing when you said work-life balance, Polish, because this is the ongoing conversation in my household, is that as an academic, I do nothing but do academic stuff. And then my family goes, well, isn't it time for you to think about other things in your life? And so, yeah, work-life balance comes once you've managed your time, and that's hard to do.
Thank you, Margaret. Giorgio.
Thanks. It's hard to supplement these points. I agree with everything that's been said. Maybe just 3 remarks. In terms of reading, I agree, read widely and read more than just antitrust and economics and technology, you know. But also read critically in antitrust. I think I'm quite concerned that over the last, I mean, it's always been the case, but increasingly so, a lot of work is ideologically driven in ways which the answer is evident once you read the first sentence of the paper, if not before. So I think students in particular should be careful that when they read a paper, they know if it embraces a particular position, and should be quite careful about this. And I think the declaration of funding that people are now putting on papers are really helpful in showing, yeah, if this person has written for this industry, obviously they will be supporting a mechanism that benefits the industry rather than the general interest. I mean, there may be a general interest, but at least we know where the person's coming from, right? The other point is, yeah, on time management. I always tell my students, you, at some point, you just have to abandon the work. You know, it's never finished. It's just, that's all I've got, and that's all I can do. So, and one tip might be, you know, if you've spent, you know, 2 months writing your LLM dissertation, spending 1 more day is not going to add 10% to your grade. It's going to add 0.0001%. So there's diminishing marginal returns. So once your supervisor tells you this is pretty good, getting it from pretty good to excellent would take you another 6 months. So just work with what you got. Don't try to think that doing 1 day's more work is going to significant marks. In terms of research topics, I mean, maybe related to what has been said by Or, study national practices. I think it's a bit understudied. I think national agencies are doing some interesting stuff. And I think because students come from different countries, they have different language capacities and are able to capture the subtleties a lot more than I. I know I'm doing a project now with some French cases, but I don't have the linguistic capacity to understand all the nuances or the cultural knowledge of understanding if the court says something with this turn of phrase, what that does that actually mean, whereas a national student from the national tradition will have a greater background knowledge. And I think we could all learn a lot from what goes on at national level in a more subtle and contextual way.
Thank you very much, Giorgio. Giorgio Monti, Or Brook, Magali Eban, thank you very much for sharing with us your brilliant thoughts on this, the substance of today's conversation, but also on much broader set of issues.